Question for today is, how do I protect my invention when working with a manufacturer? Hi, everybody. I'm JD Houvener, owner, founder, and patent attorney at Bold Patents Law Firm, and I'm excited to talk with you today. I've helped inventors now for over 10 years, achieving almost 500 patents. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. That book and our guide from this year, 2025, is right below in the Bold Inventors Kit. So grab that and begin your journey today. This question is awesome. It's for the inventor that is nice, at least asking those hard questions about how do I talk with a third party, a manufacturer, about my invention, maybe even before you filed it. Well, the key is, and this is not going to be a shocker, but a contract. Have a contract before you start making products, before you start sharing the ins and outs about your invention with a third party. This is even more true if you're doing this manufacturing overseas or out of state. Even if it's within the same state or local zip code, it's something you should have in place. There are two main parts of the contract I want to draw your attention to. First one, confidentiality. Before you get started talking or publishing or sharing your invention with anyone, make sure that it's in confidence, in writing, using a binding confidentiality agreement. Now, this is part of the contract, right? The agreement you'll have with the manufacturer about how many widgets are being made, how much they're charging you. It should be baked into the service contract. And as I'll say this about the second point coming up, you want to make sure that you're not looking at this all on your own. You should hire a business attorney, someone local that knows the state law that can make sure that even if, right, in the very rare case that the manufacturer breaches their contract, that you have the ability to go to a local court and enforce that breach to get your remedy. Now, number two, apart from the confidentiality piece, which is critical, is invention assignment. Inevitably, as you work with the manufacturer over time, the design will change. And most of the time, your design will iterate because the manufacturer may actually suggest different materials, different tooling, different types of structure or approaches or even versions altogether about how your product could be made cheaper or efficiently and get it to the retailer at less cost, to get it landed quicker. Now, all of these things are actually potentially inventions. They can be little iterations, tweaks, and changes that will turn your product into one that's more commercially viable. In the end, you want to make sure that you're getting a patent on the final product. And so all those innovations, you want to make sure that you, the inventor, the owner, will own those, even if you didn't yourself come up with them. And so that's called invention assignment. If the manufacturer themselves come up with an invention, even if they get to file their own patent filing, you will be the one that owns it. So make sure that's in the contract too. There's a bunch of the provisions that, of course, are important regarding performance. Make sure that there's no unfair competition. And then on top of that, making sure that you have a remedy to hire another manufacturer. So bottom line, work on confidentiality, invention assignment, and hire a business attorney to make sure they look at that, to make sure it's binding and enforceable. All right. Have a good rest of your day, everybody. Have an awesome one. Go big, go bold.